Welcome to Forum 360. I'm Sally Henning. Our special guest today is Bradley Dunn, the Regional Director of the Ohio Civil Rights Commission Akron office. He's been employed by the Ohio Civil Rights Commission for 21 years and has held positions of legal intern, investigator, field supervisor, and reconsideration supervisor. That is the person who reviews cases after they've been decided, correct?
Yes, the appeals.
And appeals. He's also been the recipient of the Commission's Employee of the Year for above and beyond service. And Bradley is a graduate from both the University of Akron and the University of Akron School of Law, my alma mater. He's also an active member of both the Ohio State Bar Association and the Akron Bar Association. He's the past chair of the Disability Law section. He's the past chair of the Labor and Employment Law section. And he's the vice chair of the Diversity Committee. And he's been nominated to serve on the Board of Trustees starting in July of 2017. Currently, Brad resides in Hartville, Ohio with his lovely wife, Amy, and his two young children, Spencer and Madeline. And Bradley also spends his spare time as a volunteer for the Summit County Juvenile Courts, and he is working part-time as an adoption attorney. He also does camping, and he pretends he's young and physically fit by engaging in judo and jiu-jitsu. Did I say that right?
Jiu-jitsu.
Jiu-jitsu?
Yes.
Oh, arigato gozaimasu. Thank you for appearing on Forum 360, Brad. It's a pleasure.
Thank you. It's my honor to be here, especially on such a time-honored institution such as Forum 360. Thank you.
Well, thank you. So let's start with, would you describe for our audience the important mission of the Ohio Civil Rights Commission?
I'd love to. The Ohio Civil Rights Commission is the primary educator and enforcer of Ohio Revised Code 4112, and that's the state's civil rights laws. In fact, Ohio is a fairly progressive state historically when it comes to civil rights laws. Many of our laws predate many of the federal laws. And in Ohio, our laws started in 4112 started in 1959, and it established a commission. It is our job to, as I said, educate and enforce that civil rights law. And in the areas of employment, places of public accommodation, housing, credit, and disabilities, and places of higher education. Now, not just anybody can come in and file a complaint and have a successful complaint. I mean, just because
what does it take? Who can file? You handle charges of discrimination.
Correct.
In employment?
Correct.
And in housing?
It would have to be
public accommodations?
Correct. It would have to, someone would need to allege to have a successful case with us that they're being discriminated against because of a protected class. And protected classes are such as race, religion, national origin, disability, age, and now for age it's 40 and above, sex, ancestry, military status, or retaliation. Now, retaliation is one that's often confused. Retaliation for either opposing unlawful discrimination or participating in an investigation into unlawful discrimination. And if an individual feels as if they're being subjected to unlawful discrimination because of one of those reasons, they can come in and file a charge of discrimination with us.
How does that come about? If someone feels they've been unlawfully discriminated against, either with respect to housing or employment or public accommodations, like a store or whatever, how do they file a charge of discrimination? How do they get the process started?
Well, we've really endeavored to create numerous methods to file a charge. Knowing that many of the people that are wanting to file complaints come from various backgrounds, we wanted to make it as convenient as possible. The primary method, and probably the most, the method that would behoove most people, would be to come into our regional office. Which is in Akron, Ohio. Which is in Akron. We have numerous offices across the state, including Toledo, Cleveland, Columbus, Dayton. We have a satellite office in Cincinnati, and Columbus itself. You go to your regional office, you fill out a short form. And that short form is used by the investigator to draft a charge affidavit. Once that charge affidavit is notarized and accepted by our office, it begins an investigation into the allegations. But for convenience, we also have the form online. So if somebody wanted to log on to our website, they would be able to fill out the form there. or under certain circumstances, we've been known to take a telephone charge, or actually go out and meet somebody out in the public and draft the charge for them. So we'll come to the person.
Is there a cost involved in filing a charge of discrimination?
No, our services are absolutely free.
And do individual people need to have an attorney in order to file a charge?
No, they do not. They are permitted to have an attorney through the process, but it is not a requirement.
Do you have any idea about how many people in Ohio file charges of discrimination each year, or in Akron? Obviously,
it varies from year to year. Currently, it's around 4,000 people a year file a charge with the Civil Rights Commission. Now, within Akron, I don't have that number in front of us, but statewide, it's around 4,000 people every year file charges with the commission.
So what do people need to know about the Ohio Civil Rights Commission as you think about it? What are some of the important things that people need to know about the commission?
Well, going back to what we said earlier, number one, our services are free. The second thing to remember is we are a neutral entity. We are independent fact finders mandated by the state of Ohio to investigate civil rights charges. We're not a legal advocate, so we cannot give legal advice or act as somebody's attorney or legal advocate. But furthermore, we exist for a very particular reason, and that particular reason is we generally are cheaper, faster, and more efficient than trying to file suits in court in a court of competent jurisdiction. And we were specifically designed by the legislature to conduct that process to make it easier for citizens to engage their rights.
So since you've been regional director, what has been some of the more exciting or surprising experiences that you've had as you think about it?
I think, and I've answered this question multiple times in the same way, and I think that majority of the employees around the state would answer it the same way, and that is actually serving the citizens of Ohio, the people of Ohio. It's nice to have a job where you're making a lasting imprint upon the people of Ohio. That when you can look back on your career, you can actually say, I made things better. And that's well worth it, especially when many of these cases that come across our desk are some of the most difficult and emotionally challenging cases one could ever think of. Really, this is made possible, and the reason that the commission works so well is we have a whole bevy of some of the most dedicated employees that I have ever known in my numerous experiences with private employment as well as with the government. I think the general sense is this is a calling more than it is a job. And truthfully, I can't say enough how proud I am of the staff that I supervise, as well as many of the employees across the state. Time and time again, they go above and beyond to try and service the people of Ohio. And I couldn't be more prouder of them.
That's exciting. What has been the most challenging thing about being part of this organization, being part of Ohio Civil Rights Commission?
I think it's misunderstanding of what civil rights law is.
It's not just being unfair,
right,
or being unhappy.
Well, some people believe that the purpose of civil rights law is to grant super rights in some others, as they would see it as. Some people don't even realize that they have civil rights laws in Ohio. And the truth is honestly somewhere in the middle. The purpose of civil rights laws are not to elevate somebody's rights beyond another individual's, rather to encourage employers to judge somebody not because of their age or based on their age or their sex or religion or another protected basis, but rather to approach the employee and judge them by a legitimate non-discriminatory reason. In other words, their performance, the content of their character, something that has to do with the job rather than a stereotype placed upon them because of an innate character that they possess.
Well, you know, I was representing a company and the investigator came in and asked for a list of employees broken down by sex, and I said, actually, alcohol's a worse problem. Anyway, I'm sorry, that's terrible. That's terrible. So, as you look at your charges, what is the category that seems to be the most? Is it age discrimination, sexual harassment, race discrimination? What do you see as being the biggest issue these days?
In Ohio, and it has been historically, it's the #1 alleged basis is race.
Okay.
However, the largest growing basis is retaliation. In fact, if we look federally, the EEOC, which enforces civil rights laws on the federal level, that's the Equal Employment Opportunity Commission, their number one basis is currently retaliation.
Now, you started a minute ago, and before I interrupt you, I apologize, to talk about what retaliation was. But for people to understand and perhaps prevent it from happening, could you explain a little bit more about what is unlawful retaliation?
Sure. Pardon me. It is unlawful to take an adverse employment action against somebody.
And by adverse employment action, you mean firing them or disciplining them or something
discipline,
like that?
Cutting their hours,
cutting their hair.
taking that adverse action because that individual either opposed unlawful discrimination, raised the issue that they believe that they've been subjected to discrimination.
Or somebody else.
Right, or you're correct, or they participated in a investigation to that end. So they were a witness in a civil rights investigation or something to that effect. If they are subjected to an adverse employment action because they engaged in that protected activity, that would be deemed unlawful.
So if they are actually filing a charge or if they are complaining about something that they've observed that they think is unlawful discrimination.
Yes, that is a protected activity. They shouldn't have any adverse employment actions taken against them because they engaged in that activity. Now, sometimes we get people that say, wait, I came in and filed a charge against you. Now they're issuing discipline because I'm always late. And of course, we asked, are you always late? And they say, well, of course I am, but they're not supposed to discipline. No, it's
not an umbrella.
Right.
Filing a charge is not an umbrella that protects them from being disciplined.
Right.
Shucks.
It can't be based upon you participating in a protected activity. But if you go out and violate rules otherwise, and they would normally discipline somebody under those circumstances, the employer is more than welcome to do so.
So what are the judgments that you make? How do you know the difference between fish and fowl? How do you know the difference between someone, let's say someone comes in and they file a charge of unlawful race discrimination or sexual harassment or whatever, and then they're also late, and then they claim retaliation. What's the judgment factor for you that you teach?
Right. Well, of course, there are two ways to approach a case, and that's one by direct evidence. So we have something that would indicate that the actor intended to take an action because of someone's, in your case, race. They told somebody, well, I'm going to discipline him because of his race. That's a rarity, but it still does happen. The other is to look to see how the company treats others who engage in similar behavior. So if it's somebody is getting disciplined because they're always late, we would ask them, well, company, how do you treat others who are not in that protected class when they're late? And if we start to see that there's a disparity between the two.
A difference.
Yeah, a difference between the two, we're going to start asking questions of why. Why is there a difference? And it starts to, it's not the end of the inquiry, but it really starts to look like maybe it is because of somebody's race or religion or some other protected class. So you look
at the facts. You're tuned into Forum 360. We're honored to have as our special guest today Bradley Dunn, who is the Regional Director of the Akron Office of the Ohio Civil Rights Commission and a long-term investigator, conciliator, teacher of civil rights.
One who doesn't like to have my hands being idle.
I can see that. We've talked a lot about the rights of people and what constitutes discrimination and how you know whether it's discrimination or not, or retaliation or not. Let's talk about things a little bit, instead of talking from the point of view of someone who might be filing a charge, let's talk about how a business might benefit from contacting the Ohio Civil Rights Commission.
Yeah, sure.
An employer.
An employer or a landlord or, anybody that may be on the recipient end of being a respondent, that have a charge filed against them. Number one, education is a large factor in this. As a misunderstanding of civil rights law causes a lot of employers to freeze. They're not sure what the law is or is not, and that sometimes prohibits them from being proactive. On our website, we have a number of resources that are free to the public. You can log on and see what the law says, what the law is and is not. We have brochures to help in that guidance. But furthermore, a company can call into the commission. Now, again, as I said, we cannot give legal advice, but we can proffer information. So if a business is curious if something's going to be covered, call into our office. We don't log our calls. We don't know where the calls are coming from. So we're not going to know that, X, Y, and Z business called us. Ask an investigator, this is going on. Is this something that you would cover? And does it sound like it's something that potentially could be a violation of Ohio Revised Code 4112? You don't have to use that language, but a violation of civil rights law. Again, can't grant legal advice, but we'd be more than happy to talk to the company about that issue. That is part of our mandate, education. We want that to happen. And my experience has been, as many times as I've told not only companies that I come in contact with, but friends of mine who own companies, just call in. They're still hesitant to take that action. I mean, it's the big brother effect. They're afraid that the government's out there to get them, rather than what we're really trying to do is help them to prevent these issues from becoming a charge.
I imagine you get a lot of issues with respect to disability discrimination and accommodation. What are some of the resources that you provide in that area?
Well, we provide number one, a description of what is or is not a disability. Furthermore, I do believe there's a guidance on our website pertaining to reasonable accommodations. Mm-hmm. I think most people would know I'm not to not hire somebody because they are disabled, as long as they can perform the essential job functions with or without a reasonable accommodation. But when it comes to requesting a reasonable accommodation, employers get there's much more ambiguity there. So there's resources online to show them what are the obligations when somebody requests, hey, I need my desk raised so I can get my wheelchair under the desk, or I need some time off to go through some treatments. What are the company's obligations at that point? What do they have to do to make sure they don't run afoul of the law? So
you can discuss the kind of analysis that they can go through and help them to prevent problems.
Correct, right. Can't advise them, do this, but we can tell them, most of the time, if you do this, you should be okay. In general, if you do this, you'd probably run afoul.
You see a lot of publicity about sexual harassment cases. Is that still an issue in Ohio?
Yes. I think one of the most surprising things that most people would discover is that blatant sources of discrimination still occur with frightening regularity.
Really?
We have cases of discrimination from going back to some cases that are now public record, and I could talk about it. But a landlord, or actually owner of a business that openly sexually harassed tenants, and had tenants come in who were prostitutes or otherwise. He thought that he could take advantage of them without them having any credibility because of their background.
I believe I have represented one of the plaintiffs in that case, and I believe he kept a mattress in the back office, if I'm not mistaken.
Oh, wow.
That's
not surprising.
The lead, I was not lead. The lead, I was way in the background. Way in the background.
But we've had some really gratuitous unlawful actions. I often, in some of my presentations, show a sign that literally says "Public Pool, Whites Only." Yeah. And that was posted by a landlord, and I tell him, this may look like it's a picture from the 1960s, but it's from a few years ago from somebody in Ohio. And the landlord didn't defend it on, I didn't know it was up there, but tried to defend it that there's nothing unlawful about saying your pool is for whites only. We have nooses being hung in the workplace.
Yeah.
We have, threats, open threats that are caught on tape of employees wanting to kill other employees just because of their race. We have a recent case where the landlord openly admitted on tape, I don't want you to lease any more properties to African Americans. I don't want you to hire any more African Americans. I want this to be known as a racist company. Although the gentleman didn't use African Americans, he used a much more colorful term to refer to these individuals, but we get that. We see that on a daily basis. And what was surprising to me, a hard time to be in civil rights law, was around 2008, when there was a national discussion of whether or not we're in a post-racial society. So we have this going on, and I go back to my office, and my desk is filled with these cases of people blatantly discriminating against other people. And these aren't allegations being made. These are cases that have been proved.
On the flip side of this, many of my clients are employers, you know, in real life, when I'm not doing TV shows. And they're always concerned about frivolous cases. Do you see some of those too?
Oh, yes.
And how do you separate the wheat from the chaff?
Well, by doing a thorough and proper investigation. We, as a commission, cannot prevent somebody from filing a charge. Even if it's something that we wouldn't have jurisdiction to investigate, we still have to accept the charge by statute. The commission, however, determines how much we investigate. So if we get a case that blatantly is non-jurisdictional on its face, we can usually expedite the investigation to save the employer from having to jump through all the hoops.
Do you recommend any best practices for employers to prevent unnecessary litigation, prevent unnecessary charges? Does the commission do that?
Communication, training, and more communication. I have found that there is a hesitancy to want to talk about civil rights because they believe that if we talk about it, now they'll know what their rights are and they'll go complain. Rather than exploring the issue and saying, hey, we are a company that's dedicated to make sure that you're being judged on your performance, not on the color of your skin or the religion that you profess to. And my experience is when that becomes something that's discussed openly and individuals know that is something that is of care and concern from the company, it actually limits the number of charges being filed.
Activities, priorities for the future. What do you see for the future of the Ohio Civil Rights Commission and for you?
Oh, well, I don't know and I wouldn't even presume to guess what is in store for me.
For the commission then?
Well, for the commission, the commissioners endeavor to bring government to the people. Typically, our commission meetings, they're public, are held every 3 weeks in Columbus.
The commissioners are appointed by the governor?
They are appointed by the governor.
Okay.
We have 5 commissioners that serve. And but to get out to the people themselves, the commissioners will take, if you will, the road on the show on the road. We just had a commission meeting in Dayton at Wright State University. April 27th, we're having a 2017 commission meeting at the University of Akron at Quaker Square, Ballroom B, starts at 9:30, where people can come in and see the government at work, to see what these cases are and the importance of them.
Does the public have to make a reservation if they want to be? They can just walk in.
This is their meeting.
So if a person who feels that they've been discriminated against, or a teacher, or just an employer wants to know more about the Civil Rights Commission, they can just come on April 27th to Quaker Square and go attend a meeting.
They can attend the public forum of the Civil Rights Commission. They can log online, or they can give us a call.
And they'll see actual cases discussed there with the commission?
Actual cases will be discussed. There'll be oral arguments. There can also be interaction. A lot of time I have members of the public come up and ask me questions before or after the meeting, and I'm always more than willing to engage in those discussions.
You've been tuned into Forum 360. We're honored today to have the Regional Director of the Ohio Civil Rights Commission for Akron, Ohio, which is what, 13 counties you take in, something like that?
Yeah.
13 counties. Brad Dunn, who's the Regional Director. On behalf of Forum 360, I'm Sally Henning.
Forum 360 is brought to you with support from Electric Impulse Communications, Kim and Harvey Nelson, Rubber City Radio Group, Akronist.com, Hudson Cable, Medical Mutual of Ohio, Forum 360 supporters, and the Shaw Jewish Community Center of Akron.